Hello America, this is Call of Duty Goddess. Today is March 6, 2016. I'd like to do this video in remembrance of LaVoy Finicum. This is based on LaVoy Finicum's troubles that he was having with his water rights and with the BLM or the Forest Service or whoever it was. I was given a video by someone. The video is of Dr. McIntosh on property rights on Western ranches. He also did a dissertation. I'm going to leave you links for the video of him teaching about property rights on Western ranches, as well as the link for his dissertation. And I'm going to put this up against LaVoy Finicum's troubles that he was having with ranching. I tried to research this, but I don't know enough about ranching and property rights to do anything, so I figure I'll just give all the information that's needed out there, and you can do with it what you wish. I really think it'll help some people. So anyway, this is a memory of LaVoy and his family.
This is the deed to my ranch, right here. And here is the description of my spring, along with my other assets and description of my ranch. I have half interest in Coyote Springs and Pipeline, period. Here they have a letter sent. It says, as discussed, the two-weep little tuck-up little two-weep holds half interest in White Springs. Now that's correct. Water during the permitted season of use from October 16th to May 15th, 7 months. After this time, the entire flow will be allocated to the two-weep allotment, which is theirs. Now I have a deed for half that water. They're now sending me a letter saying, no, you don't have half the water. You only have a quarter of the water, a little more than a quarter of water. Now they are taking almost another 25% of it. And they say it's theirs, just with the letter. They claim to have exclusive legislative ability and power whatsoever. That means that they can write and create laws and back it up. I'm here at my White Springs. This is my only live water on my ranch, and this is my storage tank here for it. I purchased this with a lot of blood, sweat, and tears. And there's been a few fires here in the area. And BLM came in here, set up a tank, and they drained it. They took it, just about every bit of it, to use for their own fires to put them out. And without so much as a hidey-ho or to please or we're going to use it, they just set up and they took it. I don't care if they take half of it and take 50,000 gallons of it. They can't take 100,000 gallons of it. It's mine. It's for my cows. I need it. And they didn't pay for it. They didn't ask for it. They just took it. They stole it. And it's not okay. You know, they got tankers, and they got all sorts of choppers, and they can just drop in buckets in the river over there. The Colorado River is only a few miles over there. And me, all I've got is a flatbed that can hold 900 gallons of water. It takes me an hour and a half to 2 hours through rough roads to get water out here. It takes over 200 days just to fill this dang tank. And they just stole it. It's not okay. They take more than half, they better come and ask me. Quit stealing. It's not theirs.
If it's not public land, it's not open injury and settlement. Now, why is that important? Okay, I'll tell you why it's important. It's important because the very moment public land becomes private property, the jurisdiction, the general grant of jurisdiction to the United States ceases. And the jurisdiction of the state and its political subdivisions, county, takes effect. And as a matter of fact, it even specifically says in the Forest Service Organic Act that the creation of a forest reserve does not affect the jurisdiction of the state or the rights of the citizens or their obligations thereunder. So Congress made it absolutely clear when they passed the Organic Administration Act and started creating forest reserves that there was no intent to keep federal jurisdiction over those lands. And even if they hadn't passed that, the very moment a right-of-way was established, a homestead, a mining claim, any type of private property rights, in a case called Barden versus Northern Pacific Railroad Company, the Supreme Court said it is settled law that the moment any right attaches to the public lands, it ceases to be public lands of the United States. This is what they call black letter law. The case law on this is so numerous that all you got to do is go look up the term. Don't take my word for it. I want you to go look it up, because when you see it, then you'll be convinced. And then you'll know that they've been pulling the wool over your eyes for the last 40 years. It is well settled that all land, I just said that, to which rights others is attached does not fall within the designation of public lands. Where the United States grants a right-of-way by statute to a company which files a map of definite location and the road is constructed, the land forming the right-of-way is taken out of the category of public land subject to preemption and sale, and the land department is without authority to convey rights therein. There's a couple of citations there for you. That Atherton versus Fowler case was very interesting. That was an 1877 case. There was a guy that was claiming a large amount of land in California and under a Mexican land grant. But it was later determined that the land grant was invalid. There were a lot of people who were submitting false claims of land grants at that period of time. And they set up a special court. And when they finally ruled that that land grant was invalid, a bunch of people started moving on to this guy's land and setting up cabins overnight, literally. People would move on, and overnight they'd have a cabin erected trying to stake a claim, because now officially it was public land, right? They thought. And the Supreme Court said no. Said even though this is only a possession, a right of possession, that it is not public land. Because as long as he is in possession of it, nobody else can dispossess him. He is an actual bona fide settler on the land. And even if his claim far exceeds thousands of acres, far exceeds what is allowed under the homestead law, it is still not public land. And nobody else can go on there and settle and dispossess him of land that he has settled on and improved. And in this case, his improvement was just an improvement of the forage. Okay, that'll come into you'll see how this comes in your mind later on when we start talking about range improvements. Okay? The two biggest misunderstandings about split estate ranch valuation has been that the ranch property value derives from a permit, or that the ranch has a leasehold value. You own your allotment. The term grazing allotment itself first appears in the law in 1887 in the General Allotment Act. Okay, so the term grazing allotment, that is what you own. It is an additional entry in addition to a homestead. And it was granted in the western part of the United States in areas where 160 acres or 320 or 640 was not sufficient for, quote unquote, the support of a family. Because that was the intent of the homestead laws, was to grant an amount of land sufficient for the support of a family. Not to grant some specific amount of land, but to grant an amount of land sufficient for the support of a family. So when allotments were made, they were made to the persons who had already improved the land and settled on the land. And what this was based on was the individual state range laws. And every western state had their own flavor, but essentially all the same as water rights. Okay, because up until 1866, there were some people that argued that, well, you could appropriate water, but it's not good against the United States. Okay, well, in 1866, by the act of August 26, 1866, Congress severed all the water in the West from the public lands and made it open to appropriation. Okay, what we call water rights. You guys are familiar with that? Somebody nod. Brent, you know what I'm talking about, right? Water rights. That's where water rights come from. They were the custom and culture under Mexican law. They were reenacted into state and territorial statutes. And in 1866, the U.S. Supreme Court said the actual name of the act is an act granting the right-of-way to ditch and canal owners over the public lands and for other purposes. That's the actual name of the act of July 26, 1866. But that act is probably the single most important law ever passed by Congress in respect to the western states, because it did two things. Section 8 of that act was a general grant of right-of-ways. And what it says is the right-of-way for the construction of highways over the public lands, not reserved for other purposes, is hereby granted. Now, somebody will say, forest reserves. When they were reserved, then that's no longer public land. But in the Forest Service Organic Act, it specifically says that nothing in this act shall prohibit the ingress and egress of actual settlers going to and from their homes or property, nor from constructing wagon roads and other improvements necessary to utilize their property. So even though it was a reservation, Congress said it's still open for establishment of improvements and right-of-ways. And they actually passed another act in 1899 specifically opening or stating that there are specific right-of-ways that could be granted. So remember, a right-of-way is an easement. It's a real property interest. Okay, a permit is not a property right. It's merely an inceptive license required before a property right can be appropriated, constructed, or developed. What is this, Sevier River? What's this river? Okay, let's suppose for a moment that there is some unappropriated water available to appropriate out of the Sevier River. I doubt it, but we'll just say, okay, you could go to the state engineer's office and you could get a permit to appropriate. Okay, under that permit, you could then go and you could construct a diversion, divert the water, put it to beneficial use, and thereby mix your labor with it, and thereby acquire a right of property. Is the permit a property right? No, it is not. It's merely an inceptive license. Let's say you want to build, I don't know what the zoning requirements are here, but let's say in Junction you own a house. And it's been there 100 years. There were no zoning and that kind of regulation 100 years ago. But now you want to build an addition. Okay, you got to go down and get a building permit. Now it's being regulated. So now you got to get a building permit. So you go down and get the building permit. Is your house worth more now? No, it's still the same house. Until you actually build the addition, mix your labor with the materials and create more additional value, then there is no more additional value. There's no property right by the mere existence of the permit, unless it's a transferable permit, and most permits aren't. Okay, that's a one rare exception. Down in Texas, I know they have permits for building dairies. Okay, and you go through all this rigmarole and you get your permit, then you decide to sell the land to somebody else who wants to build a dairy, and they allow you to transfer. Now it has some value because it allows you to do something that otherwise would take you a long time to do. But these permits, and the Forest Service and BLM have told you for years, they're non-transferable. Well, they're not, but they're not property either. The grazing allotment is the property. It's an actual area of land upon which you have forage and grazing rights. And I'll tell you the actual statutes as we go through this. But a permit is not property. So get that out of your head. I had people tell me that, well, I bought this permit back in. No, you did not buy a permit. You cannot buy a permit. A permit is not property. You can buy the allotment. You can buy the whole ranch. I've seen them sold separately. The base property, what they call base property, is the homestead. I've seen that sold and the allotment sold separate. I've seen allotments divided and part of them sold off. And the government has never opposed a sale. Why? Because what you're selling belongs to you. You're not selling anything that belongs to the federal government. If they have an underlying legal title to the land, then you're not selling that. And as a matter of fact, in the Taylor Grazing Act, it says nothing that the issuance of a permit shall not be construed as granting any right, title, or interest in or to the land. That's all it's saying. Just because they give you a permit doesn't mean you own the land. Okay? If you own 100 acres, somebody else owns, I have an easement over it. Can I sell my easement to somebody else? Yeah. Can you sell your 100 acres to somebody else? Yeah, but they take it burdened with my easement. See what a split estate is? Congress, and we look at a map and we see it's all green or it's all brown. Oh, well, everything must belong to the government. That is false. Absolutely false. There are hundreds, thousands, maybe millions of miles of various right-of-ways. Every state highway that crosses BLM, or Forest Service land, has its origin in this act of July 26, 1866, known as RS-2477. In reality, it's Section 9 of the Act of July 26, 1866. Or excuse me, Section 8 of the Act of July 26, 1866. And the courts have said these right-of-ways, and the whole purpose for that in the first place was because of the Homestead Act of 1862. Some guy had homestead 160 acres. Pretty soon, people would be all homesteaded around him. He's landlocked. Well, we have to pass a law. So they pass a law saying if you need a right-of-way, it's yours. That way you're not going to be landlocked in.
I also have an interesting observation from Cindy Banks about LaVoy Finicum, that he grew up on an Indian reservation. It says, it's my understanding that both his parents grew up on the same reservation. The assumption is he is an Indian. The Malheur Indian Refuge was a mount set aside for Indians by Roosevelt. My understanding is the refuge is a place of safety. Now that means LaVoy as an Indian was not trespassing on government land, but actually there by right as an Indian. That he has the right to invite any of his friends as he wanted to his refuge. Simple definition of refuge: shelter or protection from danger or trouble. It's a shelter for protection. And Cindy, I think that's a brilliant observation, and I agree with you completely. So rest in peace, LaVoy. You went out there, you cared, you did it out of love. You radiated love just in watching your videos. I didn't know you. Many people that see you didn't know you, but they felt the love that radiated from you just from watching you and hearing you speak. And I hope this video helps some farmers and the families and loved ones and friends of LaVoy Finicum. This is Call of Duty Goddess signing off, and as always, I've got your 6.